Well, hello, everyone. It's always nice when a presentation is topical, and I don't know how engaged people are on social media, but a couple days ago, the Twitter founder, Jack Dorsey, tweeted out, delete all IP law. And the ever demure and not often in the news, Elon Musk retweeted, I agree. Um, Despite that, we're going to assume that doesn't happen and intellectual property law will remain in full effect for the time being. This is the intersection of bankruptcy and intellectual property law, which is episode 2 of the Financial Poise Bankruptcy Intersection series. You can read more about Financial Poise on slide 2. Our panelists today are James Sullivan of Seyfarth Shaw, Christopher Wick of Honloser and Parks LLP, and my name is Anthony Callie of law firm of Stinson LLP. You can see our names on slide 6. And you can read our bios on slides 46 through 49, but neither Financial Poise nor we intend this to be an infomercial, so you don't have to hear me read the bios. If you want more information about us, just look at our bio slides. Regarding the slides, I'll try to call your attention to slides that are relevant to whatever we are talking about, so you can take notes if you like. But if you're only listening, don't worry, and if you're not watching the webinar, you'll be fine because the slides are not critical. We don't intend to really read off of them. I'd like to thank our co-producers, the National Law Review. You can read more about the National Law Review on slide 4. Financial Poise webinars are supported in part by sponsors. The sponsor for this webinar is Max Asset. More info on Max Asset is on slide 3. And finally, the last thing before we begin, slide 5 contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate legal advice. So without further ado, let's go ahead and get started. Chris, let's start with the basics. What are the most common forms of intellectual property that are dealt with in bankruptcies?
Thanks, thanks, Anthony. Happy to be here and looking forward to talking about the intersection of intellectual property and bankruptcy. Starting on the IP side, generally we have several types of intellectual property that we'll be discussing. Patents are the most obvious. A patent is an exclusionary right afforded to a holder of an invention or discoveries for a limited term. Generally, it's 20 years. And these are governed by the Patent Act and regulated by the United States PTO, which is the Patent and Trademark Office. There are 3 types of patents that are used. There's a utility patent, and that protects useful inventions that are novel and non-obvious is the basic term. These includes processes, methods, devices, software programs, and the like. Basically, a utility patent is what you think of when you're thinking of patents. Another type of patent is very specific. It's a plant patent, and that is exactly what you think it is. It covers new and distinct varieties of plants. We will not be discussing those any further. And finally, there are design patents, which are patents that are new, any new or original ornamental design for an article of manufacture that does not meet the usefulness standard that we use when qualifying for a utility patent. And a little over a decade ago now, back in March of 13, the Patent Office changed from first to invent to first to file. And so now we don't worry about who created this. It's just the race to the PTO. The second type of intellectual property that we'll be discussing today are copyrights. Copyrights protect original works of authorship. So to qualify for protection on a copyright, you've got to have an original work that displays at least some modicum of creativity in a fixed and tangible medium is the kind of the key phrases there. In other words, you have to write something down or produce something that other people can see. We're talking about kind of literary, dramatic, musical, artistic works are generally covered here. As we'll discuss later on, copyrights can be licensed both as an exclusive license or a non-exclusive license, which will raise issues regarding whether or not they are executory contracts in bankruptcy matters. The third type of intellectual property that we will address are trademarks. Trademarks get a little different treatment both in bankruptcy and outside because a trademark is a word, name, symbol, device, or a combination thereof that's used to identify and distinguish someone's goods from somebody else's goods. And so those, even if the source is unknown, so you don't know who owns that McDonald's that you're pulling into, but you know it's a McDonald's and that you're going to be able to get a Big Mac there and not a Whopper. So it's kind of that kind of stuff. You have to actually use a trademark in commerce. It's governed by the Lanham Act. At the federal level, there are state level trademarks as well, but they're also governed or regulated by the PTO. The other two types that you will sometimes deal with are trade secrets, and trade secrets in today's day and age is a little different because people become more cost effective. They try to keep things secret and private. And instead of getting the protection that a patent gives you for 20 years, an exclusive right to use and license this, trade secrets you can use for a much longer period, so long as you keep them a secret. But in recessions, of course, you get people that are fired or terminated, and secrets sometimes walk out of the door. So those are the major types of I think I missed one. Domain names is the final one, and right, and we all know what a domain name is. It just guides you to wherever you are on the lovely interwebs.
But about 20 years ago, those were more in vogue when you used to have the patent squatters or the domain name squatters that would buy up a domain name and then try to extort a company for huge amounts of money. I think that's fallen out of vogue, thankfully.
Yeah, it definitely has, but I think patent trolls still live on.
Yes. James, why don't you take us into now the bankruptcy world and tell us how the bankruptcy code defines intellectual property? And James, you have to unmute first.
There we go. Sorry about that. So bankruptcy code defines intellectual property to include trade secrets, patents, including invention, process, design, or plant patents, patent applications, works of authorship that are subject to copyright, and mass works also protected under the Copyright Act. And again, all of this is only to the extent protected by applicable non-bankruptcy law. So the bankruptcy code oftentimes will look to non-bankruptcy law to determine what kind of status type of property will be given and how it will be treated in the bankruptcy case. Sometimes the bankruptcy code will look to either federal statutory or federal common law. But most often when it relates to property, the bankruptcy code and the bankruptcy courts will look to applicable non-bankruptcy law. So in here, the definition of property in the bankruptcy code explicitly limits the definition of intellectual property to those items that I just identified, and only to the extent that each of those items receives protection under applicable non-bankruptcy law. Now, you may ask, why does it make a difference? Why does the bankruptcy code even define intellectual property, and how could it potentially matter in the context of a bankruptcy case? Well, typically in a bankruptcy case, debtors will often sell its assets or try to get out from under agreements relating to property rights that it may have, whether in terms of contracts or leases and the like. So when the bankruptcy code addresses asset sales or how to deal with contracts in a bankruptcy case, the definition of intellectual property makes a big difference. And so that's why it's very, very important. What's not included in the definition of intellectual property? There are two primary ones. The first one is trademarks. You might ask, why would the bankruptcy code treat trademarks differently? As Chris sort of alluded to earlier, trademarks are a little bit different from, for example, copyrights and patents, in that a trademark is highly associated with a business itself, whereas copyrights and patents are not necessarily tied to a particular business. And therefore, if a company is in bankruptcy, its trademarks are going to be associated with that company. And it might be confusing if provisions of the bankruptcy code, which allow for parties to use intellectual property, notwithstanding, for example, a rejection of a contract, it might be confusing to have multiple parties utilizing a trademark, and may cause confusion in the marketplace. So that's one of the reasons why Congress decided to treat trademarks a little bit differently. Another
also, don't you like? It's a somewhat ironic that you're talking about trademarks and in bankruptcy, but nevertheless, it's the goodwill, right, and the quality of the underlying product that's being protected, right? And here we are in Chapter 11 talking about, hey, this product has a lot of goodwill. Yeah, but it's broke. So
you can't really sell the goodwill separate and apart from the business. So if the business is going to operate as a going concern, right, you can't sell the trademark separate and apart from that going concern business. You might be able to break it down into its parts if you're liquidating, but you can't really just sell a trademark without some aspect of the business associated with it, or at least it's like going to be heavily limited as to how you might be able to accomplish that. The other item that's not included within the definition of intellectual property is really foreign IP, right? So foreign IP rights are a little bit different, and so that might be treated under that another country's law, and there's some interesting dynamics which we'll get into in a little bit when we're talking about how foreign bankruptcy law may impact the rights under U.S. intellectual property law.
Thanks, James. So we've taken a look at basics of IP law, what is covered, and then how the bankruptcy code defines intellectual property and what may be missing. Let's talk a little bit more about policy now. James, we'll stay with you. Are the policies underlying the bankruptcy code and intellectual property laws at odds with one another? And, if so, can you identify some of those tensions?
Sure. There definitely are to some extent, right? Because the bankruptcy code is designed primarily to provide a fresh start to a debtor, as well as to maximize value for creditors and to provide for equal treatment, or at least as equal as possible treatment for creditors. Intellectual property law, on the other hand, is not concerned with creditors. It is not concerned with, maximizing value necessarily. It's interested in protecting the interest of owners of intellectual property and inventors of intellectual property and creators of intellectual property, primarily from infringers. So they're not looking to protect creditors of IP owners, but only protect the IP owners from infringers. So there's an interesting dynamic that occurs in a bankruptcy case, because you may ask, okay, well, which takes precedent? Bankruptcy law is a federal law. Patent law is a federal law. Copyright is a federal law. So, it's not necessarily self-evident that one would trump the other, right? There's preemption issues that come into play. And so what the bankruptcy courts are going to try to do as much as possible, to the extent that there's a conflict between applicable intellectual property law and the bankruptcy law and the policies behind them, the bankruptcy court is going to try to balance those as much as possible, and not necessarily cast aside one in favor of the other.
And James, you was on one of these slides, but you had started to mention some of the issues related to foreign IP law. Do you want to maybe discuss the Kimonda decision and some of that tension between foreign IP law and the United States bankruptcy scheme?
Sure. So, in a hypothetically speak, the Kimonda decision, I'll just kind of like briefly discuss it real quick, was a Chapter 15 case. So Chapter 15 is a section of the bankruptcy code that allows a foreign debtor, one not based in the U.S., to file a case in the U.S. in order to seek relief from the bankruptcy court in aid of the foreign bankruptcy. So in this particular case, there was a debtor based in Germany. And what it wanted to do is it wanted to terminate a bunch of U.S. patent licenses that it had granted to parties, including parties that were based in the U.S. The German debtor argued that German law should apply, and German law allowed the German debtor to reject these license agreements. And then the U.S. license holders obviously objected. And we're going to get into it a little bit later, but U.S. bankruptcy law provides some protection for licensees of intellectual property in a bankruptcy case. So the U.S. license holders were arguing that U.S. law should apply. And what the court ended up doing was applying basically a balancing test, right? There's a provision of section Chapter 15 of the Bankruptcy Code, explicitly 1522, which provides that the bankruptcy court, when deciding what type of relief to grant in favor of a foreign debtor, is allowed to consider the interest of creditors and other parties in interests to ensure that those interests are adequately protected. And so in this particular case, that is exactly what the U.S. court did, is that decided that it was not going to recognize the German insolvency law, which allowed this type of rejection to occur, without protecting the interests of U.S. patent holders who, when they obtained those licenses, were assumed that they were going to be entitled to the benefits of U.S. bankruptcy law and the protections that U.S. bankruptcy law provided. The court below also relied on Section 1506 of the Bankruptcy Code, which also permits a court to refuse relief if it's manifestly contrary to the public policy of the U.S. However, the Fourth Circuit did not specifically address that, but that would be another basis for a bankruptcy court to refuse a request by a foreign debtor in trying to impair or impact the rights of U.S. holders of intellectual property.
So intellectual property is frequently licensed to users other than the owner of such property. And we talked about in bankruptcy, there's this concept of the fresh start that the code is designed to give debtors. And one of the tools that a debtor has in its toolbox to achieve a fresh start is to sell its assets or to assume and assign assets, including executory contracts. So that brings us to a concept that is or a phrase we don't hear anywhere other than in bankruptcy context, and that is executory contracts. Chris, can you tell us what is an executory contract in bankruptcy, and how do bankruptcy courts go about defining?
Sure. Interestingly, is we talk about the bankruptcy code and definitions and all those kind of things. The bankruptcy code doesn't define what an executory contract is. But we can assume that IP licenses will fall under our definition of an executory contract. Otherwise, this would be the shortest presentation that Financial Poise has ever given. So speaking generally, there is the countryman definition is the most frequently cited and used definition of what is an executory contract, meaning that it's just it's a contract under which both parties, the debtor and the non-debtor, have so far underperformed that they still have significant contributions that are continuing in nature, so much so that they would constitute a material breach if either side did not perform that contract. And really, the key here is that you've got the lack of performance by either side that constitutes a material breach is important. If you've got the performance of one side is conditioned by the performance of the other side, it's not really an executory contract. And by that, I mean, if party A provides widgets and party B agrees to pay for widgets upon receipt, while you do have things going on both sides, that's not executory enough. You've got to have a continuing obligation to do something. And bankruptcy courts have really kept a pretty low bar on what constitutes an executory contract. However, one thing to look for in assumption or rejection pleadings is debtors counsels like to drop little footnotes where they reserve the right whether or not this contract constitutes an executory contract, because everyone usually just likes to flow to assumption, rejection, or assumption and assignment, depending on what the debtor's doing, and they don't want to get caught up in this initial thing. There is another definition that is sometimes used for executory contracts, and that is called the functional analysis approach. The functional analysis approach attempts to take a more holistic approach or concept of what they're doing. You look, or the court would look to the nature of the parties. It would look at the goal of the reorganization. What's the debtor trying to do here? And it's truly the most one-sided definition I've ever seen, because it literally looks to see, will the acceptance or the rejection of the contract benefit the estate? And as I'm sure we'll get into with 365N later, right, there are protections against the non-debtor licensee, or protections for that non-debtor licensee. So, you know, it kind of, when you're looking back at what is an executory contract, and is this acceptance or rejection going to benefit the estate? It's not the same thing as a business judgment rule, but that sometimes, when, especially when a debtor is trying to kind of manipulate the course in which they're going, you'll sometimes see a functional analysis approach to whether or not it's an executory contract.
So James, why don't you take us to the section of the code that deals specifically with executory contracts? Tell us a little bit about section 365 of the bankruptcy code. What is it? What is it? And what does it allow parties to do? And what issues does it raise with respect to intellectual property?
Sure. So Section 365 of the Bankruptcy Code addresses the treatment of executory contracts in a bankruptcy. As we alluded to earlier, a debtor in bankruptcy has some options that it has available to it when it's deciding how to treat an executory contract. So typically what it's going to do is it's going to analyze the contract to decide, okay, is this a contract that has value for the debtor, and therefore we can keep this contract for the benefit of creditors, or should we try to reject it because it's a burdensome contract? Maybe the debtor made a bad business decision when it entered into it, and possibly even the particular contracted issue may be causing the debtor to lose so much money that it actually caused the bankruptcy to occur. So the policies behind the bankruptcy code provide the debtor with a mechanism to analyze the contracts, decide whether they're favorable for the debtor or unfavorable, and then make decisions as to how to address these contracts or deal with them. So the first option is to assume the contract. Now, in order to assume a contract, A debtor is going to have to cure any existing defaults and pre-petition deficiencies under the contract, and it's going to also have to provide the counterparty to the contract with adequate assurance of future performance. It's not going to be able to assume contracts where the counterparty will be unfairly prejudiced by not by basically forcing them to agree to a situation where the other side, the debtor, is not performing. The next option would be to reject it, right? As we talked about, if there's a contract that's a losing proposition for the debtor, it's losing money under the contract. The bankruptcy code typically allows the debtor to reject that contract. And the third alternative is if it's looking to sell some of its assets in bankruptcy, oftentimes it will look to also assign any contracts related to the assets being sold to the buyer. So oftentimes in connection with the sale process, contracts, the debtor will have to assume the contract and then assign it to the buyer. And there's some additional hurdles that a debtor will have to overcome in order to do that. In order to do that, the debtor is going to have to show that there's no limits on assignability. Generally speaking, the bankruptcy code will not enforce anti-assignment provisions in contracts, but with respect to intellectual property, which we'll get into in a little bit, the bankruptcy code has a slightly different analysis. And so the buyer is also going to have to, the debtor and the buyer are also going to have to show that the buyer is going to be able to perform under the contract going forward. So those are the three primary alternatives that are available to a debtor in terms of how to treat its executory contracts in the context of the bankruptcy case.
Chris, I believe you mentioned before that most IP contracts are going to be executory contracts would fit in that bucket. And James just talked to us about assuming, assigning, or rejecting executory contracts under Section 365 of the Bankruptcy Code. So assuming that IP contracts are executory in nature, can they be assumed, assigned, or rejected like any other contracts in bankruptcy?
A short answer, yes. Longer answer, every lawyer's favorite answer, is it depends. Once IP licenses are typically considered executory contracts, going all the way back to the Kmart decision in the early 2000s. I think it specifically says that. But we're going to start getting into kind of the minutia and the differences here. It depends whether the executory contract or the IP license agreement is exclusive or non-exclusive. So before we get into the treatment in bankruptcy, let's maybe stating the obvious, but an exclusive license means that only the licensee can use that IP in a certain field or a territory. Sometimes that when it's an exclusive license, it's considered an assignment of a property right. And so that's non-executory because, right, if only that one party uses it. A lot of times when we think about debtors in bankruptcy, we think about the debtor as the licensee because no one who's smart enough to create intellectual property that somebody else wants to use is ever going to go bankrupt. And I'm saying that completely facetiously. But you need to determine whether or not the debtor is the licensee or the licensor. The other type of license when we're looking at our non-exclusive licenses, and this just means that the licensee gets limited rights and the licensor can license that IP to others as well, which obviously that can come into play when you are rejecting, and you may only reject with a certain licensee as opposed to another. Now, if you look going back to the different types of intellectual property that we talked about, at least the main three. With patent licenses, those are absolutely 100% always going to be executory. The licensee's got obligations to mark products, to report problems, and then on the flip side, the licensor is the duties to defend infringement claims, most likely to indemnify a licensee for any loss if something arises in an infringement claim. And then when you get down to copyrights, Sometimes those are executory, because in those instances, the licensor will often lack an ongoing obligation beyond just simply licensing the dramatic work or the music. And the difference can be, sometimes you can argue that a covenant not to sue is a continuing obligation. And the courts kind of have gone both ways on that. With a copyright, the issue will turn on whether the license is exclusive or non-exclusive, because the continued work by the licensor, other than just updating obligations, will make the license executory. And the final one, in trademark licenses, those generally are considered executory as well, because both parties still have that continuing obligations. The licensor's got to enforce the trademark against others and indemnify for loss, while the licensee's got to adhere to that quality control, pay royalties, and things along those lines. So when you kind of get into the treatment, and maybe we'll talk about that a little later on the kind of what happens with rejection and assumption and the like.
James, can you take us into what protections the bankruptcy code offers to parties in IP licenses?
Sure. So, as we kind of talked about just from a high level, the bankruptcy code doesn't necessarily just adopt whatever the agreement says, right? So the bankruptcy code has other policies involved. That's why provisions in license agreements that say that it's ipso facto terminated upon a bankruptcy, those are not typically enforceable. Also, any anti-assignment provisions in an IP license agreement, again, those might be enforceable, but the bankruptcy code will not always give effect to them. Even if there's a consent in an IP license, the bankruptcy code, as we'll get to in a little bit, won't necessarily give effect to that or enforce that. So the primary provision in the bankruptcy code that provides some protection to licensees of intellectual property is 365N of the bankruptcy code. 365N was implemented specifically for the protection of licensees of intellectual property, because they found that as a result of bankruptcy filings, there was a cratering of the rights of intellectual property licensees and even downwind licensees that had a big impact on the market. So what 365N does is it gives and this only applies to executory contracts. So again, it does not apply to non-executory contracts. But with respect to an executory contract, it gives a licensee the ability to continue utilizing the intellectual property, even if the debtor rejects the license agreement. But the licensee would have to continue paying any royalties related to the license agreement that it is obligated to pay under the agreement. So, for example, if a copyright licensee wanted to use copyrights pursuant to a license agreement, and that license agreement required it to pay, let's say, $100,000 a month, or whatever it is, it's going to have to continue paying that. It's going to have to make an election to keep its rights, and it's going to have to pay that in order to be able to continue utilizing it. And it will be allowed to do so not only through the term of the license, but also it can exercise any options and extensions that are contained in the agreement going forward. The other option is not very commonly exercised, but would be to just put in a claim. Most bankruptcies, creditors get paid pennies on the dollar. So if there's a 10% distribution to creditors, the licensee would only get a 10% value on its claim. So most often, licensees are looking to enforce their rights in a bankruptcy case.
Thanks, James. Chris, Can you talk a little bit about IP licenses and the concept of rejection of an executory contract, an IP agreement in bankruptcy?
Certainly. So, the idea of rejection with a license is kind of what does rejection mean? Is it a complete severing of the relationship, or as James just said, sometimes parties have continuing rights that will allow to stay on. When the debtor is the licensee receiving the license, and they decide to reject, it's a little cleaner because the debtor is paying some form of a royalty there and says it's just too expensive, I don't need this. It gets more difficult or tricky if the debtor is a licensee and they need whatever that underlying intellectual property is to maintain their own business. If it's software or something that it's being used. Back in 2019, there was a Supreme Court case called Mission Product Holdings versus Tempinology. Tempinology, this case, it addresses several important bankruptcy law questions regarding the treatment and the rejection of intellectual property licenses. In particular, and I guess I'll back up for a second that Tempinology was the debtor, and it's this company that owned the intellectual property to specialize for like specialized products such as towels, socks, headbands, and other accessories that would allegedly stay at a low temperature even when being used during exercise. But Tempinology then license or reaches an executory contract and an agreement with Mission Product Holdings, granting Mission the distribution rights for some of its products, a non-exclusive license to their IP, and then granted Mission a license to use Tempinology's trademark and logo to sell these products. Well, after accruing a multi-million dollars of operating losses in 2013 and 14, Tempinology files for bankruptcy in September of 2015. And this little issue of whether or not what does rejection mean floats up to the Supreme Court, where ultimately the court rules that a debtor like Tempinology, when they reject a contract under 365 of the Bankruptcy Code, it does not rescind the rights of the other party, like Mission Products, that they already had. So in other words, rejection is a breach. It is not a termination. And that's the kind of the key ruling that you can come back from there. So an IP licensee can retain their rights to continue to use it. So this ruling in Tempinology clarified that if a debtor grants a license of intellectual property, the licensee, i.e. Mission, can continue to use that IP even though the licensor, Tempinology, files for bankruptcy and rejects the contract. Now, Tempinology or a debtor may not have any continuing obligation moving forward, but that's right, but you can still use it. It's significant for trademark licenses because previously trademark licenses were always treated differently than patent rights. And this, they said, no, even with a trademark, if a debtor licensor rejects, you still, Mission, have that right as a licensee to continue to use it. So it's a very favorable decision to protect the licensee and other contract counterparties to the debtor. And Tempinology really kind of gave more certainty. It also reinforced the concept of rejection equals breach, and rejection doesn't equal rescission. And finally, it really kind of helped clean up some prior court interpretations, because the First Circuit had earlier ruled in favor of the debtor, suggesting that a rejection terminated Mission's rights. And the Supreme Court obviously overturned this, resolving a circuit split.
Yeah, I was a little unhappy about the timing of that, Chris, because I had a case pending when that was up, and I was in the Fourth Circuit, and I represented a party that had a manufacturing agreement with the debtor, as well as a license agreement, intellectual property license agreement, specifically dealing with the trademarks. And we were left in a lurch because the debtor decided it was going to sell the intellectual property rights out from under my client. And we, at the time in the Fourth Circuit, the law was not favorable. And we ended up having to participate in the sale process in order to protect our rights, because it wasn't just the intellectual property rights that we had. We also had this manufacturing business that was relying upon, the license. And so I was praying that that case was going to be decided a little earlier, but it didn't quite, ended up working out okay for our client because we were the successful bidder, but it definitely caused a lot of aggravation for us. And so I think many people in the marketplace are very thankful that technology case finally came out, and I think it makes a lot of sense.
Well, it really cleared up a previous issue that I think was created either in the Fourth Circuit or by the Supreme Court, that ultimately led to this creation of 365N. And that was in 1985. Lubrizol uh, was a licensor, and the Fourth Circuit issued an opinion that held that the licensee's rights to use a license mark, the trademark, terminated upon the debtor licensor's rejection of the agreement. And then in 1988, when I was in seventh or eighth grade, that change, right? It kind of got to the point where Congress said, whoa, 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 we need to do something here to protect the licensee, the non-debtor licensee. So enter 365N. However, since trademarks were kind of treated differently than patents were, we had an issue, because it's like, well, a trademark, that's that kind of ongoing goodwill and quality of product, and you shouldn't be allowed to use someone's right. But really, what Lubrizol was trying to do is the same thing that any debtor or licensor would be doing in this context. We're like, well, we weren't charging you enough. We want to be able to charge you more. So it to me, it's interesting when it kind of gets into really the underlying policy arguments here on how things stand.
The amazing thing really is because this problem was existing for so many years, and Congress was constantly notified that there was a problem here, and they never did anything to fix it. So obviously it was up to the Supreme Court to finally make sense of things.
Right.
But just the IP lobby wasn't as strong as the landlord lobby. So if you know anything about 365. Chris, I want to just come back to something on technology that maybe is just a question that it raises. So the debtor can reject the contract, but then you have the non-debtor licensee that is still using that IP, and the Supreme Court says they can still use that IP. But it's not completely unfettered, right? The contract isn't gone in the sense that, let's say it expires by its own terms 2 years after that rejection had occurred. The licensee doesn't get to continue to use that ad infinitum anymore, right? They're still bound by the terms of that contract, right?
Right. It's almost like a foot fault in the contract. Like the contract still exists. So all the other applicable terms of it, including the length of the contract, exists, right? Okay, you're gone, but if there's a term that prevents you from using it 6 months or 12 months or 2 years later, then that's not going to you don't get to use it 2 years and a day later at the end of your term. Unfortunately, a lot of IP licenses are done kind of perpetually. So long as you're doing this, it's great, and I will continue to get your royalties from it. And then one day the debtor licensor goes away. right? Because they're liquidating, and the licensee says, well, wait a minute, I can still use this, I can still make money off of this, I want to continue to use it. And it, sometimes it can fall back all the way back to that, whether it's an exclusive license, is it a property right? Did you transfer the whole bundle of sticks over to the licensee, or non-exclusive? But again, right, it's all like everything in bankruptcy, it's always premised on something else. And typically it's that non-applicable bankruptcy, or non-applicable bankruptcy law, or applicable non-bankruptcy law, sorry, that matters at the end of the day.
So we've talked about rejection for some time. Let's flip the coin and go over to what happens when a debtor assumes an executory contract dealing with IP law. Chris, can you take us through that scenario?
Yeah, I can. That's kind of hopefully it's the more exciting, because we've got things going on when instead we're just talking about rejection. So 365 A and B are the code sections that allow or create the opportunity for a debtor to assume the contract, i.e., continue to use it. They're going to have to pay the cure costs, just like with every other executory contract. And then in the event of a sale, which more Chapter 11s are these days, 365F authorizes that debtor to assign the executory contract to a third party. There are cases, though, however, that are you need, and ultimately you need to figure out whether or not the non-debtor party to the executory contract has the ability to accept performance from the debtor or a third party. Because if they don't, then we've got issues there. So it can be your ability to assume the agreement can be limited, and that's kind of as James said earlier, the applicable law piece. It doesn't include the enforcement of anti-assignment provisions, because in bankruptcy those are considered ipso facto clauses, and so that they're kind of from a policy basis not allowed to to enforce those anti-assignments. So in with 365 and the assumption, there's basically a couple approaches, there's three approaches to dealing with whether or not a debtor can assume the contract. The majority approach is called the hypothetical test, and it reads 365C literally. The assumption or the ability to assume is restricted if applicable law excuses performance from a party other than the debtor. So you're really kind of pushing it out to other parties. And I think in our materials we referenced the Catapult Entertainment case arising out of the Ninth Circuit in 1999, which was a non-exclusive license, which was being assumed, and it was followed up by the Fourth Circuit in 2004 in the Sunterra case. The majority approach is followed by the Third, Fourth, Ninth, and 11th Circuits. Again, it's more straightforward. The second of these options is the actual test. And this it rejects the hypothetical test and focuses on the actual intention of the debtor licensee who's seeking to assume the license. Unless the license will actually be assigned, then we don't care what the non-debtor licensor, whether they're required to accept or render service to an entity other than the debtor, because the reality is you're not dealing with another party. So it kind of makes sense. And that's why the First and Fifth Circuits adopted it. It really kind of goes, it reverts back to a case-by-case inquiry that to kind of deal with it. And the third is one of the few times that the bankruptcy court for the Southern District of New York was kind of out on a ledge with really not tethered to reality at all. And it's called the Footstar approach, coming out of a case from 2005 in the Southern District, as I mentioned, where the bankruptcy court for the Southern District of New York read that 365C1 only bars the trustee and not a debtor in possession. So for the first and only time that I'm aware of, we make a distinction between the two from assuming an IP license if applicable law would excuse the non-debtor counterparty from being bound by the assignment of the license. The court reasoned here that the word trustee did not include debtor in possession, although they're kind of used simultaneously throughout the rest of the code. Accordingly, though, according to the Southern District of New York, the right of the non-debtor party to object to the assignment doesn't affect the right of the debtor in possession to continue to assume and use that executory contract. And doubling down a couple years later in the Adelphia communication case, the bankruptcy court for the Southern District of New York kind of followed this logic and reasoning and allowed it to continue moving forward.
Not followed by any other courts in any other district, Chris?
Nope, no, not at all. And kind of maybe referenced here and there, but only to kind of point out the fact that the Southern District of New York is way out on a ledge by itself there, and then usually would go back to the majority approach or the actual approach, which aren't that different, but I mean, it just kind of I tend to like the actual approach because it really just kind of looks at it on a case by case basis and says, hey, this is what's going on here. Is the non-debtor right? You don't want to allow a non-debtor to be in control. Going back to those policy differences and the intersection of it, you can leverage or give a non-debtor licensee to licensor too much leverage here to prevent a debtor from getting that fresh start. So let's look and see what they're actually doing. But at the end of the day, if the bankruptcy courts are not going to be debtor friendly, no one's going to be debtor friendly. So they kind of find ways to manufacture results that allow a debtor to do what it wants to do. If it's assumption and assignment, or rejection, typically when you're the non-debtor, either as a licensor or a licensee of intellectual property, you're kind of fighting an uphill fight.
This kind of provision, I think Congress was really looking out for us bankruptcy lawyers, kept us very busy for the last bunch of years.
They want to give us something to do, right? I mean, we've been talking about executory contracts for about an hour now, and it's still just not a defined term in the bankruptcy code.
You don't make it too clear, otherwise there'd be nothing for us to do.
Yeah, can't have that.
Nobody wants to deal with bankruptcy or bankruptcy attorneys, so they will let us try to work through these problems by ourselves without solving it for us. It's like, parents dealing with children. So, obviously 365 issues it's really where a lot of the substance is in bankruptcy and intellectual property. So we're, if you're following along at home, we're running behind on versus the slides. So why don't we switch over to maybe some practical considerations in bankruptcy. And James, if you can just sort of quickly start walking us through 363 sales in bankruptcy that involve IP assets, and maybe someone who's considering purchasing assets that include an IP bundle of rights. How do parties go about valuing those bundles? How do you deal with sensitive, confidential information in that process? Why don't you walk us through that?
Yeah, it's definitely tricky because all these issues with 365, and then there's the issue about like a 363 sale. What rights does a buyer even buy? Like 363 versus 365, which one controls, right? Can a debtor sell IP assets, free and clear of a license agreement or property interests, and that if a debtor has IP interests that are subject to other interest holders. There's a divergence in the law on that. Some courts have said, well, as long as you make it clear what you're trying to do and you give the other parties an opportunity to object, yeah, you can sell the assets free and clear of those interests. Other parties, other courts have not been so lax in terms of allowing the debtor to do that. And so that's an interesting aspect of it. A similar issue pops up occasionally when you're dealing with a sale of a property subject to a lease. And that's been litigated as well. So when a buyer is kind of going through it, typically what they'll do is they'll enter into a confidentiality agreement with the debtor with respect to any IP assets that are subject to confidentiality issues, such as trade secrets and sometimes some other aspects of it. And they'll do a claim analysis. Like for patents, they'll go through each of the claims and because these assets the patents themselves have value independent of the assets which they're tied to in the business that they're tied to. Same thing with copyrights. You may have a film library or a music library that has value independent of it, and there's professionals out there that all they kind of do is evaluate these assets, evaluate the royalty streams or income streams that these things are subject to, and then come up with a value. So it's a very it's a nice little side business out there for valuation professionals to kind of come in and value these types of IP assets. And I'm involved in one right now where the debtor retains a professional that's going to sell a film library, and it's a very, very specialized area. And so that's pretty much it. It's just a lot of you're gonna go into a data room and you're gonna analyze these things, but at the end of the day, there's somewhat of a it's somewhat of an art to kind of go through it and to kind of value it. There's an objective piece to it as well as a subjective piece to it.
Chris, just to turn to you on this subject, any strategic implications in formulating a bid or any risks associated with IP rights during a sale that you think are noteworthy?
Definitely. I think one, patents, you've got to analyze them separately from an operating business. You've got to look at the value of the patents, and it's easier to do so when there's evidence of use and of the patent inventions, i.e. market size, market share. Understanding that market share allows the buyer, to better understand the range of what a reasonable royalty may be, or that the patent can command. It's really kind of important for the license to be able to generate the revenue, and if it's being used, then what it is. It's when you get out into the kind of hypothetical of the you see this with a lot of medical companies that don't make it. They were doing some research, it got too expensive, someone pulled it, and that's kind of the difficult thing when you don't have kind of that value out there. But you've got to you really need to look at the debtor's marketing share and market share to develop what you think the value is for your bid.
One of the things that I'll do is when I'm representing a buyer is I'll require that the sale order have a provision that specifies exactly what the rights are, because it eliminates the confusion that might result down the road as between various owners of various aspects of intellectual property, or maybe license holders, because the last thing you want is to buy an asset subject to litigation, right? So oftentimes what you'll see buyers do is they'll put a provision in the contract that says, okay, I want a court order where the bankruptcy court is going to determine that the rights that I'm buying is X. And therefore, if somebody disagrees with that, you make it very obvious. If somebody disagrees with it, they can raise an objection, and you can have that sort of decided before the sale is finally approved.
Yeah, I
So
think
we're-
the other thing that you probably need to do is you if you can, and you're not your NDA doesn't prevent you from doing it, you better go out and talk to whoever's that non-debtor party is at the other side of your license agreement, and see if you have a friend or a foe on that other side. Are they going to try to prevent you, or do they want to work with you, even though you may be presenting yourself as the white knight and the debtor is just kind of, you know, this dumbling doofus that you're going to make things better for them, but they may not want to do, they may just be done with you. And so your market share and your ability to have a paying royalty stream may be drying up faster than you think.
And you may also want some employees of the debtor. Like if some of the employees are going to be coming, you're going to want to make sure, hey, do I have the expertise to monetize these assets? Maybe I need to talk to some of the debtor's employees and see if I can get them to come with the assets, you know? So there's all these issues pop up.
So we are at the end of our hour. I'll just toss out this final, and we only have time for soundbite answers. Any parting advice that you would give to people that are dealing with IP issues in a bankruptcy proceeding?
Well, the one advice that I would give is that a lot can be done to minimize risk when you're entering into these license agreements. There's a ton that I can do to protect you in advance. Once the bankruptcy is filed, like if you're trying to figure it out once the bankruptcy case is filed, it's a lot more difficult. You just have to react to all this various case law and what your rights are. So I would highly recommend speaking to someone who's very familiar with these issues while you're entering into the license agreement and not wait until later on.
I couldn't agree more. You took the words right out of my mouth.
Great. Well, thank you very much, James. Thank you very much, Chris, for your time today. Thank you to Financial Poise for hosting this webinar. And thank you for all of you listening at home and hearing us talk about the intersection of bankruptcy and intellectual property law. And that concludes our webinar for today.
Thanks, guys.
Thanks, everyone.